I bought the property and the agreement of purchase and sale is a boilerplate agreement of purchase and sale that says that it's supposed to be vacant, but it's not vacant. This is a really interesting question because if you Google this, other law firms' blog post will appear. And candidly, it's wrong because what it says is that, basically you as a purchaser always have to close even if it was supposed to be vacant. And if you fail to close, you're going to be in heaps of trouble. And here's an old case from the divisional court from 30 years ago that basically says that. And the case that they're referring to, it is good law. It's a perfectly fine case. But what happened in that circumstance is that a purchaser was going to be buying a property and it was supposed to be vacant. So it's around 4:00 or something and the tenants haven't left, but they're literally in a moving truck. Like they're in the process of moving out. The buyer says, well, technically they're not out yet. And so I'm not going to close because my agreement of purchase and sale says I'm supposed to get it vacant. You haven't provided it vacant. I'm not closing. What ends up happening? The seller, obviously very upset, says that's a technicality. They were on their way out. They were literally in the driveway. No. And so the seller sues the buyer. The seller actually does win the lawsuit. And the judge says, you know what, buyer, you should have purchased the home, in my opinion, is that, as a buyer, you shouldn't rely on a technicality. If the tenants are literally in the process of moving out, if they're in the driveway backing up, you should probably close. Otherwise, you're taking a real risk. But it does not stand, that case does not stand for the proposition that you should always close if the tenants aren't leaving. And I say that because I think something like 20 or 25 years later, another case came out, very similar circumstances. A buyer bought a piece of property. It's supposed to be vacant. It's not. The buyer made it clear in advance, I'm going to live here. So obviously it has to be empty or I'm not going to be able to move in. And the seller says, I tried, I did everything within my power, but I'm sorry, I can't get them out. What ends up happening in that case is the buyer says, well, I'm not closing right now because that's not what I bargained for. And they don't close. And then a year goes by and the buyer sues the seller and says, you know what? I want the house that you agreed to sell me and I want it at the purchase price we agreed to and I want it vacant like I was supposed to. Wouldn't you know it? The judge sides with the buyer. So basically what all this means is we've got two different cases involving similar circumstances.
Right.
The first case basically means you as a buyer shouldn't try to get away with a fast one. Like that wasn't even the real reason why the buyer didn't close. The buyer just didn't want to close on that transaction. He was trying to find any reason why he could get out of it. The second case is a case where the tenants were never going to leave. They weren't in the process of moving. It wasn't vacant, period. And so in those circumstances at law, no, you don't have to close.